My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. A lot of times people are under the mistaken impression that if they have a custody arrangement where maybe the child lives with them and visits dad during the week and on alternating holidays and alternating weekends, and they sort of have a shared arrangement, but they decide they want to leave the state with the child, then it's just a question of filling out a form, that it's just a quick analysis by the court, and since they have custody already, they get to go. And if they believe that, they learn very quickly that such is not the case. In order to get an order to change the legal residence of the child, you have to have a hearing and the judge has to make a ruling that it's in the best interest of the child to make that departure. So if you live in Michigan and you want to move your child to Florida and your ex still lives here in Michigan too, you're going to have to file an appropriate motion to change the child's domicile. And it's not a two-page motion. I live here, I got a job offer there, it'll pay me a few more dollars, so therefore I want to go. That's not going to cut it. The court is not going to look at what's in your best interest. The court's going to look at what's in the child's best interest. So therefore, at our firm, when we prepare motions to change domicile, they got all sorts of things in them, including but not limited to the reasons why you want to leave, a cross-reference between where you live now and where you propose to live, an analysis of the difference between the crime rates here and the crime rates there, an analysis of the proposed school, hopefully that school will be a higher ranking and better for the child, an analysis of how close you'll be to the school and what the social opportunities are for the child. All of these things get brought in, and when we do this, we bring all these statistics to the court, and oftentimes these motions, like I said, it's not a two-page motion, sometimes these are an inch thick, as we provide the court this huge volume of information, which is a way of giving the court a way to say, you know what, that this really is a better choice for the child. These are better schools. The child has medical conditions better served by doctors out there. There's more family out there for the child to be involved with, although not one of these factors alone will necessarily carry the day, but all of them combined may well give the court reason to say, you know what, this is really the better deal. Understand one thing though, even if the court, after a contested hearing, decides, you know what, I'm going to let this guy move to Alabama with the child. I think it's in the best interest of the child that that occur. Even if that happens, understand that that's a tremendous grace that the court has given you. You're not entitled to it. The court gives it to you, and in exchange for it, the court's going to want certain things. For example, you're interfering with the day-to-day or weekend-to-weekend visitation of the other parent. Expect that the court is going to enter an order changing it, because it won't be every other weekend because you live so far away, but changing it in some way to give the parent an equal opportunity to engage in their parenting time with the child. And that may look very different than what you have right now. It may look something like this. It may be that the child is with you during the academic year, but during all the vacations and during the summer, there may be a big switch where the child is with the other parent. And what does that really mean? Think about that for a minute. Yes, the academic year may be 9 months long. So you got 9 months, the other side's got the better part of 3. That seems like a good deal for you, right? But understand, what is the academic year? The child's in school all day. Between 8 and 4 is nothing. All you got the pleasure of is squiring the child around back and forth to school, doing homework, eating dinner, and the child's up for an hour and goes to sleep. So all the difficult times might be in the hands of the custodial parent who's got the academic year, and all the fun times, the vacation times, the summer times, the holidays, all the free time where you can really do bonding type things with your child, that may go in large measure to the other parent. So you have to understand, this is a rose that has a lot of thorns. Removing the child to a new place may be good, but it's not without some challenge and sacrifice on both ends. If you have any questions about that, reach out. We'll be glad to help you out.